1, 2, 3, 4 everybody head to the courtroom floor. 5, 6, 7, 8 it's prime time so don't be late. 9, 10 here we go again, we got us a few of these sovereign citizens.
Okay, this is the matters of State of New Jersey versus Emir Colonel Chauncey L., also known as Cornell Hall, also known as Cornell Dixon.
For objection, for the record.
No. We're not going down that road. We're not going down that road. Everybody else sit down. Have a seat. Have a seat. That's 0807727I, 0302282I, 0804441I. Mr. Luciano, would you note your appearance for the record?
Good morning, Assistant Prosecutor Michael Luciano of the state.
All right, last time we were in court, the court made a ruling. Excuse me, would you note your appearance, please? All right, court made a ruling, in essence, allowing Mr. L. To represent himself in these matters. Subsequent to that, the court has received 2 other filings from Mr. L. Sir, you are.
Sir, I am Alfred Zael from the Aboriginal Law Firm.
Are you a licensed practitioner?
I am not.
Well, on the other side, sir, on the other side of the rail. Thank you. Subsequent to that ruling, the court has received, I believe, 2 other filings from Mr. L. And in one of those filings, he's raising a jurisdictional issue. So the court, upon further reflection, given the nature and complexity of the issues that have been raised by Mr. L., the court is rescinding its previous ruling and will make a determination that until a licensed practitioner in the state of New Jersey substitutes in for Mr. L., the court will enter an order that Mr. Kiesler will remain as counsel.
Objection. For the record.
It's overruled.
Objection. For the record, I have not authorized the Office of Public Defense or John J. Kiesler to take this matter.
Okay.
To represent this.
Very well.
The office. For the record.
I got it. Until there is a licensed practitioner in the state of New Jersey.
Objection. The practice of law cannot be licensed by any state, and that's according to Schwar versus Board of the Examiners 353 U.S. 238-239.
Objections overruled. Until there is an attorney, a licensed practitioner here to represent Mr. L., court is recognizing Mr. Kiesler as the attorney of record.
Objection. For the record, on the record, we'll let the record show, the rule of professional conduct states, RPC 1.0, a law firm denotes a lawyer or lawyers in a law partnership, professional corporation, sole proprietorship, or other association authorized to practice law, or lawyers employed in a legal services organization or the legal department of a corporation or other organization. http://www.judiciarystate.nj.us/rules.
Until an attorney authorized to practice law is representing you, Mr. L., the Public Defender's Office, Mr. Kiesler, will represent you.
Objection. For the record, the corporate body politic that has authorized the Aboriginal Law Firm's Secretary of State authorization number is 003.
The fact that you listen to me, Mr. That's it. That's it. I'm tired of this. Now, if you come in here again with this mess, and I'm going to call it mess on the record, you're going to be arrested. We're done. This matter will be continued till November 10th. If there's a substitution of attorney from somebody licensed, the fact that the Aboriginal law firm may have some standing with the Secretary of State is not the issue in this case. It's a question of whether, in fact, the The law firm has an attorney licensed to practice in the state of New Jersey. The matter is continued to November 10th, 2008 at 9 o'clock. Thank you.
Objection.
I'm done. I'm done.
May I put this on the record, please?
You can put whatever you want on the record. I'm done.
For the record, on the record, let the record show, I have filed a writ of coronam juris, a demand for termination or state the proper jurisdiction to all matters concerning the items of subject.
I know. I got it. I already placed it on the record. Place it on the record. November 10th, 9 o'clock. That's it.
For the record, I give honors to Judge Smith. Thank you.
All right, good morning. This is under indictment 08-04-0441. Counsel, your appearance, please.
Good morning. Assistant Prosecutor Mike Luciano from the state.
And Cheyenne M. Cushionmurel, would you state your name for the record, please? Your attribute for the record, please.
Cheyenne Matilda Cushionmurel on behalf of the Marrakesh Empire Aboriginal Law.
All right. I want to ask you a couple of questions, please. The first question I want to ask you is, are you employed?
Objection, ma'am. This hearing is supposed to be about jurisdiction. This court has no jurisdiction. The court has no jurisdiction to determine its own jurisdiction for a basic issue in any case before a tribunal.
Well, if I have no jurisdiction to determine my own jurisdiction, how are you going to get that issue resolved?
Listen, this case in this courtroom is a culpable, incompetent court of jurisdiction. You can't, according to federal case law, you can't set another hearing to reach and determine your own jurisdiction. As I've stated for the record plenty of times, I'm only handling threat, duress, and coercion, and because the prosecution falsely holds my property, and I'm here to clarify that matter. Other than that, I'm here under threat, duress, and coercion. It is completely against federal case law. It has power to act, and the court must have the authority to decide that question in the first instance. That's Rescue Army versus Municipal Court of Los Angeles. A departure by a court from the recognized and established requirements of law, however close apparent adherence to mere form and method of procedure, which has the effect of depriving one of a constitutional right, is an excess of jurisdiction. You have the flag right behind you, ma'am.
May I interrupt you for a moment?
You may not, ma'am.
And would you, when you're done speaking, would you let me know so that I can ask a question?
I'm not obligated to answer any questions, so I have no intentions of answering any question.
Well, I'll ask it anyway, and then I'll ask it anyway, and you can decide what you want to say.
Thus, where a judicial tribunal has no jurisdiction of the subject matter on which it assumes to act, its proceedings are absolutely void in the fullest sense of the term, Dillon versus Dillon. Courts enforcing mere statutes, as it is to my understanding, that this is a statute, not a constitutional violation of law. In fact, one of the hearings I had with you, you said people are not charged with constitutional violations. I don't understand how you could be enforcing statutes and you have the U.S. flag behind you, as if you hadn't taken an oath to uphold the Constitution. Courts enforcing their statutes do not act judicially, but merely ministerially. Thus, no judicial immunity, and unlike courts of law, do not obtain jurisdiction by service of process, nor even arrest and compelled appearance. Boswell versus Otis. I've been here 3 or 4 times on the threat, duress, and coercion. Prosecution doesn't even have folders in front of him. He has no objections. He has nothing to say. He cannot prove jurisdiction. This court should have been dismissed this case. This is a colorable court of incompetent jurisdiction. The fact that petitioner was released on a promise to appear before a magistrate for an arraignment, that fact is circumstance to be considered in determining whether the first instance there was a probable cause for the arrest. Monroe versus Popper. There is no discretion to ignore the lack of jurisdiction. Court must prove all jurisdiction facts related to the jurisdiction asserted. A universal principle as old as the law, is that proceedings of a court without jurisdiction are a nullity and its judgment then without effect either on person or property. This case has already been put before the federal court and you will be receiving a notice of removal very shortly. This court has no jurisdiction. Prosecution can't prove jurisdiction. This case shall be dismissed, and it will.
Did you file a notice of removal with the federal court?
Yes, you will be receiving it shortly.
All right. Well, when I receive it, I will rule on it. This is my question to you, however. Are you employed?
I'm not employed. I'm not employed with any corporations incorporated with the state of New Jersey.
Are you employed with any corporation that's incorporated outside of the state?
Objection. I'm not here to answer questions about my employment. The last time I was made aware of this was supposed to be about whether this court has jurisdiction, and clearly it doesn't. A question about employment has nothing to do with whether this court has jurisdiction, so I'm not obligated to answer those questions. Now, I shall not be answering any more of those questions that are not pertaining to jurisdictional facts.
Well, this is my question to you. I asked it before. If your position is that this court has no jurisdiction to determine its own jurisdiction.
That's the objection, man. That is not my ruling. That is not my holding. I've given you the federal case law regarding such. And maybe you can take some time out that you need to do to recheck that. But that's what the case law says. It's not what I said.
Well, I do have jurisdiction over you. Number one, you're here in my courtroom.
Objection,
Number
man.
two,
You do not have jurisdiction over me. I'm here by way of threat, duress, and coercion. The federal case law stipulates already that compelled appearance and arrest warrants doesn't give a minister acting ministerially and not judicially enforcing their statute's jurisdiction. That's incorrect and false. You do not have jurisdiction because I'm here. You've told me before when I was here that you would lock me up if I didn't come, which was threat, duress, and coercion.
I think that you misstate what I told you.
Objection, ma'am. I have not misstated. I have the videos. I have it on repeat 24/7. I've seen you say it.
I don't recall that I said I would lock you up.
Oh, well, objection, ma'am. That's on the record.
Well, you can object all that you want, sir. And I will continue to have a difference of opinion about that. All right. Well, we'll continue with today's proceedings then. And I certainly appreciate the courtesy that you extend to me. All right, Mr. Walker, I know that you are here. You wish to be heard, sir?
Your Honor, I have Kevin Walker appearing on behalf of the Office of the Public Defender. We did receive after the last hearing a court order directing the Office of the Public Defender to represent this defendant. I did file a motion for reconsideration, noting that there has been no indigency determination, which is an essential component of our appointment. So I would ask respectfully that an indigency determination be made at this time, absent that the earlier order directing to represent this defendant be vacated.
All right, thank you. Do you wish to be heard on the issue, Mr. Luciano?
I don't judge.
All right. I have inquired of Cheyenne Mutada Kushamurel concerning his employment. He tells me he is not employed in the state of New Jersey by any corporation, and therefore I determine that he does not have the present ability to pay for counsel to proceed in this matter.
Objection, ma'am. I don't know this gentleman. I haven't made any contracts with the Public Defender's Office. I don't know what that was an attempt to do, but he does not have the authority to speak for me. So I would appreciate it if any non-identified parties determining to act on my behalf first fill out an IRS Form 56 and notify the IRS that they're acting in some sort of fiduciary capacity.
All right. Let's talk about the issue of, Mr. Walker, I want to talk about the issue of jurisdiction. One of the issues that has been raised in this case and has been raised over and over again that really needs to be determined before we can proceed with it is with regard to jurisdiction. I have received, it was filed with the court, it was received in my chambers on January 7th. I'm not exactly sure if it was filed downstairs on a different day. Something that has been entitled a non-negotiable affidavit of fact to dismiss with prejudice for lack of personam jurisdiction, lack of discovery, and lack of an injured party. It purports to raise the issue before the court of lack of jurisdiction with regard to Cheyenne Mutada Kushamir L. Despite what Cheyenne Mutada Kushamir L says, this is not an application to the court to dismiss anything with anything. There are certain ways, as you are aware, Mr. Walker, to bring issues before the court. what we need to do is have the issue brought before the court properly by way of a notice of motion. I don't even know if Mr. Luciano got a copy of this, but certainly you know that any motion filed has to be served on the prosecutor. How much time does your office need in order to do that? And did you receive a copy of this?
As I have not received a copy of that, and before I address that issue, I would respectfully request that you inquire into this defendant's assets to see whether he has a present ability to retain private counsel.
He tells me he isn't employed by a corporation, so.
Objection. This is obscene.
Sir,
I do
this
not.
is a conversation that I'm having with Mr. Walker, not with you.
This is.
And
He
the
cannot
way you
speak
didn't
for
want
me,
me
man.
to interrupt you, I would like you not to interrupt me or Mr. Walker.
Objection. This man cannot speak for me, man. I haven't filled out any public defender's applications nor contracts to agree to that. You cannot force me against my consent to have someone who has I have no formal contract or agreement with to speak on my behalf. I'm a natural flesh and blood man. I don't have to have, yes ma'am. I do not have to have an attorney at law, a colorable attorney at law, de facto attorney at law, propose or purport to speak for me in any regards to these matters at hand.
When you asked me not to interrupt you, I didn't interrupt you. I'm asking you not to interrupt me. I would appreciate it if you would not interrupt me. Well, I've inquired of him. He tells me he's not employed.
Judge, I think he indicated he's not employed by a corporation in the state of New Jersey. I would respectfully request that your honor ask him whether he has any employment at all.
Do you have any employment at all, Cheyenne Mutada Kushamirel?
Objection, ma'am. I'm not here to answer questions from a third-party perspective from a de facto
I'm
attorney
asking
at law.
a question.
However, for the record, my job in service to man is to uplift fallen humanity. That is my job.
Do you receive a compensation for uplifting fallen humanity?
My job is to uplift fallen
Do you
humanity.
receive any compensation for
Only the compensation of goodwill that I receive
uplifting
from God.
fallen humanity? All right. So I take it that you don't receive any money for that. Do you have any bank accounts, stocks and bonds, things of that nature?
Objection, ma'am. I'm not going to be answering any of these questions as they're unintelligible and they have nothing to do pertaining to jurisdiction. As it was told,
Unintelligible. Which of the words did you not understand, sir? And I will use different
I don't
words.
understand the entire proceeding. This is colorable and foreign to me. I'm from a different society. We're not used to these proceedings. These colorable proceedings. And
You
you're
can
asking me
say to
questions.
me
Excuse me.
over
You're asking
and
me
over
questions that are not
that you do
relative
not
to
understand and that it is
jurisdiction.
not intelligible, and I do not believe you.
It doesn't matter if you believe me, ma'am. I don't
completely.
understand any of these proceedings. I don't understand the questions and the nature thereof. They don't have anything to do with jurisdiction. Jurisdiction hasn't been proven, which this was supposed to be a hearing about jurisdiction.
But no one filed an application with this court for the court to determine the issue of jurisdiction. A non-negotiable affidavit of fact to dismiss with prejudice for lack of personam jurisdiction is not an application to this court to take any action whatsoever.
Objection, ma'am. Haynes v. Keller 404 U.S. already stipulates that you must accept that affidavit as it is a written form of communication in regard to matters as such. Haynes v. Kennedy, maybe you need to check that out. But either way, you're supposed to accept that as an unorthodox affidavit of fact.
Well, I don't know what a non-negotiable affidavit of fact is.
You don't know, excuse me.
I don't know what a non-negotiable affidavit of fact
I have
is.
negotiable here. I don't know what you have there.
Here,
ma'am.
take a
I
look
don't
at
want
it.
to see it. I have
Here,
one
sir.
right here.
Officer, would you show this to him?
Objection. I do not choose to see that. I have the copy right here. Mine
Well, you
says
can have anything you
non-negotiable.
want. I want you to look at what I have there. Just point out the word to him, please, and then bring it back. You gonna look at it, sir?
Objection, ma'am. I've already stated that I will not be looking at it. I have a copy here. Mine says non-negotiable affidavit
good.
of fact.
Well, I'm not the one that filed this, so I'm not the one that put it in. But in any event, there is no proper application before this court. There is no unorthodox application before this court. This court, according to your statement, lacks jurisdiction to determine its own jurisdiction, and absent a proper application, it's never going to happen.
Objection, ma'am. I haven't stated from my own opinion. Again, courts enforcing mere statutes do not act judicially. but merely ministerially. Thus, no judicial immunity, and unlike courts of law, because obviously this isn't a court of law, do not obtain jurisdiction by service of process, nor even arrest and compelled appearance. Boswell versus Otis, 9-How.336-348 to wit. You want to take a look at that? I don't know.
No, sir, I don't want to look at it. I don't want to look at it.
I'm asking this
Sir,
gentleman.
you don't get to talk to him.
Understand.
You can talk to me if you want. Well,
I'm
anyway,
uncomfortable.
let me know.
With him standing there, man.
That's too bad.
Well,
He's going to remain standing there until I tell him otherwise.
And this is threat to Russian coercion. It's clear that this is a colorful court of law.
Well, it is colorful. If you look around, it is colorful.
Colorable means.
Oh, colorful. I thought you said colorful.
Oh, no, I didn't say that, man. I said colorable.
Oh, okay.
Colorable court of
Okay,
law.
colorable.
Yes,
Okay,
de
I thought you
facto.
said colorful.
De facto. Colorable means that this court has no jurisdiction and it doesn't enforce law, but mere statutes, which are not law. Having violated any constitutional laws, already stated for the record that I have a treaty of peace and friendship via 1787. Article 4 that signifies that I will have the right to be exempt from examination. No one in here has put their status and nationality on the record. The U.S. flag is behind you and you choose to disregard anything dealing with the Constitution. This is a colorable court of law. The notice of removal has already been filed, so whatever takes place here today is just a colorable de facto proceeding, and you will be receiving shortly the notice of removal. And then when you receive that, you can make your determinations about how you're going to handle that, how the prosecution is going to handle that. But as far as any other question goes, man, I'm not obligated to answer them. I shall not be answering them. And it is a violation of my rights.
Are you finished speaking so that I can speak now? Again, I am satisfied from what little Cheyenne Mutada Kushamirel has said that he lacks the present ability since his job is uplifting fallen humanity and the only compensation he receives is the grace of God. And I find that he lacks the present ability to obtain counsel to represent himself. If in fact, however, this matter is going to be removed to federal court, I don't have a copy of the notice of removal, so I don't know what the status of it is. We, of course, will take no further action in this court. I'm not aware of it being filed, but I take Cheyenne Mutada Kushmirel's word that something was filed with the federal court that purports to be a notice of removal. If it's the same as the kinds of things that get filed with me, I'm not sure it's ever going to happen, but we'll do that. But in any event, what I will do is, there are several things that I want to do today. I know that your office needs some time, and I do have a copy of the non-negotiable affidavit of fact, which I will make available to you, and we'll give it, I think. The first thing that I want to do is this. In this matter, which is under docket number or indictment number 08-04-0441, there are two named defendants. There is Cheyenne Mutada Kushamirel, and there is
Miss Mutoda.
Mutoda?
I don't understand about your phonetics. I have to pronounce words. Miss Mutoda.
Mutoda?
Mutada.
I thought you had told me it was M-U-T-A-T-A.
No, M-U-T-O-T-A.
I stand corrected. Cheyenne Mutoda Kushamirel.
Precisely.
And the other person named in this is Nobel Amir KCL. And I am going to, sua sponte, sever these matters so that there are it will no longer track as one case, but will track as two separate cases, so that I can list them on separate days and deal with them separately. Let's see. March 23rd, sufficient time, Mr. Walker?
I think so, Judge.
All right. Then this matter shall be and hereby is continued until Monday, March 23rd at 9 o'clock.
Objection, man. The notice of removal is already in. You will be receiving it today. So,
If I receive it before March 23rd at 9 a.m., I am aware of my obligations when a matter has been removed to federal court. If for some reason the federal court does not accept it, or it's not properly filed, or there's something else, that's the next stage for this proceeding.
Objection,
Thank you very
ma'am. I will
much.
not be participating in any more of these proceedings.
Do what you want.
I'm sorry, I can do that.
This is the only notice that I will give you of the proceeding on March 23rd at 9 o'clock in the morning. We don't send out letters reminding people. We simply expect that you will be here. Thank you very much.
Be contacted by my office and we'll arrange an interview in the office.
Do you have his address?
It's on here.
Yes, I have this.
The P.O. box is right here.
Objection. If you attempt to contact me and negotiate any contracts with me, you will be getting sued in federal court too as well, sir.
All right. Thank you very much.
I object to any court-appointed officers for standing in. Is this being recorded? I'm being violated. My due process is being violated. I have the right to speak to the record. And if you want to take a stand down, then
Let me ask you a question.
and the question is,
What's the question? The question is, do you wish to be represented by an attorney for us to discharge SCP-00342 a private attorney or public defender?
I need to know what laws we're working under, because I already objected to any public defender, officer of the court. Any. They are incompetent.
Are you going to get any private counsel?
I am private counsel. I'm an authorized representative.
You represent yourself, sir?
I'm the authorized representative for the trust. I'm the trustee of the account.
Are you pleading guilty or not?
I'm not entering any plea.
In that case, I'm the court will start designated not guilty.
Okay, so
The people
are
object.
you an Article 3 judge? Is this the Article 3 court? I'm not here to challenge the charges. I'm here to challenge the jurisdiction. You told me that you have jurisdiction.
Motion for jurisdiction has been denied.
Based on what account? Are you a party in the matter?
State ready for trial.
No, the state on the state will be ready on the 7th of October, Judge, when we usually try cases for the property.
Objection. Objection. Is this party?
The people object.
Let the record reflect that the judges are violating due process of law. What law are we working under? I'm here on the Treaty of Peace and Friendship, 1786, 1787, recently signed by your Presidents Barack Hussein Obama, and I'm here to enforce the Constitution, the rights of indigenous people, and the Human Rights Charter. Now, if we're here on the doctrine of discovery, which is a Christopher Columbus story, I object. This is not an Article 3 court. You are not an Article 3 judge. These are all statutes, ordinances, and resolutions that do not apply to the natural people of America. Objection. Have you received my doctrine of discovery?
Yes, I have, sir.
Have you received my written affidavit, my proclamation?
Yes, I have, sir.
Have you received the United States John Kerry sign sealed on that trademark, that trade name?
Sir, be here on October 7th. There'll be a benchmark for your arrest. Thank you.
I thought this was a trial. Wasn't this a trial?
Let him use a bit. Let it reflect that the judge left the bench.
Still has not stated for the record what laws
He abandoned ship.
on. Let the record reflect that the case has been dismissed because the judge abandoned the bench. Have a good day, sir.
Hey, we broadcast the motherfucking live, baby. It's drying hard, and TDC, Mr. Skittles, the Young Slim, of course you recognize, hey, we finna go down here and do the Marcus Garvey third good march on these motherfuckers, you know what I mean? Finna do some real gangster Moore shit. These motherfuckers trying to take a nigga to court, drag him up on the court. I'm finna do the Geronimo, I'm finna represent, you know what I'm saying, for the ancestors. Slim, you got anything to say about that?
Man, keep your head up, keep your head out of the judicial system, man. That's all I gotta say, man.
But when you get in, fuck with Mr. Skittles, and I'll be your motherfucking lawyer, whatever. Real talk, baby. TDC, 20 Click Entertainment. They think we out here playing with this shit? They think we playing, or they think we finna do this shit? You know I'm nervous in the motherfuckers. This white man is a...
You understand why we're here today?
Can I ask you a question? Are you close?
Nope. I'm not. Yeah.
Okay, that's what I want to ask you. I got a letter. I got this letter right here. This is what I want to know. I got a letter saying I don't owe child support, but I owe custodial support. Something like that.
Okay.
But before we get started, 28 USC 1602 to 1611. Foreign Sovereign Immunity Act says I got the right to challenge the jurisdiction and the status and the nationality of the courtroom.
Okay.
And I'm going to challenge that.
Okay.
For starters. Now, I don't, and the same thing. I'm sorry, can I ask you your name?
My name is Miss Trailer.
Miss Trailer?
I just wanted to leave that little piece in to show that he misspelled lawyer. I thought that was fun. The video isn't much more educational than that. I mean, he's an idiot. So, yeah, we'll finish watching it. It's a couple minutes long.
Trailer, for the record, I don't recognize you. I don't recognize this person. I don't recognize no one in this courtroom. To recognize in the Black Law Dictionary, they have a contract. I don't have a contract with anyone in this courtroom.
Havent entertaining right now. Which case is this? Number 36. Okay.
And such as in a fraud, for the record, let the record state in a fraud.
We don't create records, sir. This is Mr. Bedford. I'll talk with him. Okay, yeah. Go ahead and have a seat, Mr. Bedford. I'll call you back up. I'm Miss Reader. I'm the attorney for the state. If you'll have a seat out there, I'll call you back. Thank you.
What's your name?
My name is Miss Reader.
Miss Reader?
Yes.
Okay, Miss Reader. Miss Reader, I got the right to
Is
challenge
Mr. German here?
jurisdiction and status and nationality of you.
Okay, she will speak with you. Have a seat.
Okay.
Thank you.
You're welcome.
Let's see who you want to call now. Thank you. With this few people.
1602 to 1611. Foreign Sovereign Immunity Act says I got the right to challenge the jurisdiction and the status and the nationality of the courtroom.
Okay.
And I'm going to challenge that.
Okay.
For starters. Now, I don't, and the same thing, that means you're a foreign entity. I don't even have to say citizen, you're supposed to be the court. Because I am what? I'm Native American. I'm not a 14th Amendment Negro. They mixed my people with the Negro slaves that brought over here. They tried to treat them in 1876. So there's a lot of Black Law Dictionary.